explanation and appeal in the matter of Cobden and Cobden.
Yes, Mr. Pearce-Smith.
Please, Your Lordship, I'm here for the appellant, Daniel
Yes.
Cobden, who's behind me, and my learned friends, Mr. Jordan and Fairley, appear for the respondents.
Yes. I can tell you that we've read the judgment, we've read the skeleton arguments, we've read Sires, and we've read Buyer.
I'm very grateful for that, and also for pointing out the pronunciation. I had it as bar here, but it's helpful to know.
I'm not sure how to pronounce it either.
I'm grateful. My Lord, there is an application by the respondent, and I don't know how the court wished to deal with that. It's not my application. I would oppose it. It was an application to adduce more recent evidence to explain the current position, and the position is it's in the bundle, so that the court can take it into account to give any essay.
Well, let's hear the appeal.
Very well. My Lord, the essence of this appeal relates to the fact that the judge in this case made an order which we say was financially unfair. He didn't make the usual order. The usual order was one which would have undoubtedly been financially fair. It wasn't an unfair financial outcome had he made the usual order. The usual order would have been to place the assets of the partnership, principally the farm, up for sale on the open market with permission to the parties to bid. And that would have ensured one of three outcomes. One is it would be possible, and it wasn't excluded as a possibility by the evidence, that a third party would come along and make an offer for the farm which exceeded any amount that either Daniel or Matthew was able to offer. The second possibility would be that Daniel would buy it, and the third possibility would be that Matthew would buy it. And those possibilities would occur in one of two ways. One is that either of them would be prepared to match or overtop an offer from a third party, or else they might end up competitively bidding for the farm themselves. And of course, if they were competitively bidding for the farm, they would both be in the same boat, because they would both have all of the same advantages as a purchaser of the farm as each other, because they would be able to carry on the business seamlessly, and if there were any advantages in relation to tax or employment or other matters, then they could deal with those points. Those were also matters which they could take into account in deciding how much to offer in relation to the farm or the business, the assets of the partnership. So that would be a fair outcome. It would be a fair outcome financially. The reason that the judge gave for rejecting that as an outcome is that he considered that it would be unfair, but not unfair on a financial basis, but what was, in my submission, essentially a moral basis, on the basis that Matthew was the more deserving partner, because his efforts as a partner in expanding the business were worthy in some way of being recognised by a possibility, well, by an order which allowed him to buy at a lower figure than his brother would probably offer, or which a third party might potentially offer. And I say that that's wrong as a matter of principle. And I say that it's wrong as a matter of principle because we're dealing with a partnership. A partnership is a commercial relationship. By definition, it is something which is intended, or it's a relationship based upon making a profit. And the objective of the court when dealing with a partnership which has dissolved reflects that commercial basis. It seeks to achieve an outcome on the dissolution which is financially fair. That, in my submission, is the guiding principle which underpins the jurisdiction as a whole, as explained indeed by Sires and in subsequent authorities. If I can pick up on one specific point in this general context, it is the fact that the judge chose or decided that the special position of either of the brothers in wishing to purchase or to buy the other one out, as it were, to make a bid, was something which shouldn't be taken into account. And in his judgment, my lord, he mentions that in various places. The first place where he does so is at page 68 in the main bundle.
It's 97 you're talking about.
It starts at 95, my lord, yes.
95.
My pushing is moving slowly. Sorry, it's page 67, forgive me. So at 95, he explains that Daniel, if he was to bid more than the market value, if the market value means a third party, he would be paying over the odds in preserving his own share. I say, and in acquiring Matthew's share. At 96, he then gives an example in relation to the purchase of a tractor. And then at 97, he explains that if Daniel was to do so, to make an offer at a price which was higher in effect than the valuation evidence, the result secures financial gain for him and avoids any concern that under a sire's order, Matthew might have acquired his share too cheaply. Then at page 78, paragraph 151, he comments again on the absence of financial benefit for a partner who outbids the other for a partnership asset at a price above that which a third-party purchaser would pay for it. And his conclusion that that's irrelevant is expressed and confirmed at paragraph 334 on page 114, where he says, I've explained in section C above why Daniel's own desire to acquire the farm at a higher than open market value cannot, in my judgment, influence the court's decision on whether or not to make a sire's order. The problem with that as an approach, my lord, is first of all it treats Matthew and Daniel as not being part of the market. But in my submission, they are part of the market. And there's nothing in the authorities to suggest that they shouldn't be part of the market. My lord, in the decision of Lord Justice Hoffman in Hammond and Brearley, which is in the authorities bundle, section D, item 10.
I'm sorry, I'm behind you.
Sorry.
So,
So it's in volume 1, I think, section D. The authority is item 10 in that
yes.
section, and the pagination, the page is page 340. Well, this is, as you aware, is the decision in which Lord Justice Hoffman then was made his observation that it's notorious in the Chancery Division that size and size is an authority more frequently cited than applied. Paragraph 8 where he considers what order to make. About 4 lines down, he says it follows the plaintiff is unlikely to do better and may well do worse by sharing the prices realised by public auction than by receiving his share of a valuation in which the position of the defendants as special purchases can be taken into account. So it seems that Lord Justice Hoffman considered that the position of one of the partners as a special purchaser was something which can be taken into account.
But doesn't the judge say at 334 that that was put to Mr. Townsend, who didn't accept it?
As far as
line 3 of paragraph 334, addressing the special purchaser suggestion more generally, Mr. Townsend did not accept it.
that was in relation to the ownership of land. What he wasn't addressing was the basic point that there's an advantage for each of the partners in acquiring the other's share. It's an advantage which is relied upon by Matthew, because he says if I buy the share, under a sire's order, then I avoid tax, or I have a reduced amount of tax, and I can carry on the business, and indeed other third parties may not be so affected. But the fact that his interest is something which can be taken into account is not something which should be excluded by the court in the exercise of its discretion. The approach taken by Mr. Townsend was quite simply to value the assets as though they were being sold on the open market. He wasn't being asked to value the assets on a going concern basis, nor was he being asked to value the assets on the basis that either Matthew or Daniel would be buying out the other.
Well, the judge, I think, makes some comments about that, and who asked for what kind of expert at the CMC.
Yes. Well, I say that should be irrelevant. At the CMC, the claimant, Matthew, proposed that there should be valuation evidence and suggested a joint valuer, and the defendant agreed to that. And if I can pose the question rhetorically, how could the defendant resist such a request? Because the court would almost be bound to make an order for valuation evidence if one of the parties required it. And of course, on Matthew's case, he required valuation evidence. So the mere fact that the defendant didn't resist the request for valuation evidence shouldn't count against it.
Yeah, but I mean, the defendant could, for instance, have asked for a business valuer who would value the farm as a going concern, but didn't make that request. I think the judge
that's correct.
The judge says that.
Yes, and that's correct. Just on that particular point, the making of the order for valuation evidence. It wasn't limited to valuation evidence of partnership assets. District Judge Wales made a wider order which also includes the valuation of non-partnership assets. So in agreeing to a valuation, what the defendant was doing was agreeing to something which no doubt the court hoped and the parties hoped would enable the parties to structure a settlement. We know that that didn't work, but a valuation conducted or ordered by the court of the CCMC serves more than one function. It may serve the purpose of a party who seeks to rely upon it, but it also may help to settle the case. Well, look, while we're on that particular point, can I perhaps just take you to the pleadings,
Yeah.
which are in the core bundle.
Yes.
The main particulars claim are at item 2 in section C, and they start at page 156. And if one goes to the end of those particulars and looks at the relief sought by the claimant in the prayer, that's at page 173 in the bundle. The claimant claimed to an order providing for the fair value of Daniel's share in the business and assets of the partnership to be determined if not agreed. So it's a prospective order which is sought. First of all, there should be an order to provide for the sale of Daniel's share, and then there's to be a process by which that price should be established, the fair value. My lord,
What's the point you're making about that?
well, I was going to take you to the defence, my lord. It's page 197. Paragraph 66. Uh, 66.3. That was the way that it was responded to by the defendant. It's denied the court should make an order for the valuation, the fair value of Daniel's share in the business, assets of the partnership. So even the process of the court making an order for valuation was in issue. At no point did the defendant abandon his primary case, which is that the order that the court should make is the usual order. In my submission, as a matter of strict logic, evaluation isn't required in those circumstances, because if the court makes the usual order, it's that process which establishes what the value of the assets is. So the defendant didn't oppose the approach put forward by Matthew. Matthew sought the appointment of a single joint expert, and he agreed to it. But what he didn't do was give up on his primary case. It has always been his case. So the arguments which have been ventilated and which do form a significant part of the judge's judgment, in my respectful submission, aren't on the point. The simple point is, what would the outcome have been if the usual order had been made? I submit that it is almost inevitably the case that the outcome would have been that a higher price would have been paid for the assets, because the amount that was decided upon by the court on the basis of the valuation was at lower figures than than Daniel himself had offered prior to the dissolution of the partnership and the commencement of the action. It set up.
Yes, I mean, I just wonder whether there aren't two points wrapped up together here. One is, should the judge simply have ordered a sale of all the assets?
Yes.
Or was he entitled to make an order which permitted Matthew to buy out Daniel? And if the latter, at what price? Now, it's commonplace in an unfair prejudice petition, for instance, and I know that deals with companies, not partnerships, for the court to say that one shareholder shall be entitled to buy out another. And then there is a second stage at which the price is fixed.
Yes.
Now, on one view of the relief claimed, that's what Matthew was asking for. So in principle, I can buy out Daniel, and then we'll determine the price at which that should be done.
Yes.
Rather than simply fixing a value at trial, possibly, maybe one.
Yes. That, frankly, is what I had envisaged the court would do, and you would have seen what the judge says about the exchanges which took place at the pre-trial review. But the point, the key point, is that what the court should be striving to do is to achieve an outcome which is financially fair. The possibility, but in reality, the near certainty that a higher figure would have been achieved, if only for the reason that Daniel himself had shown a genuine interest in buying out Matthew's share, was something which shouldn't have been ruled out of the equation. This is an unusual case, and perhaps to grasp the nettle, an exceptional case. But the exception in this case is that there are two equal partners, both of whom want to have the farm. I don't think, apart from Malik, that there's another case of two equal partners competing to buy the assets of the partnership. In that case, the judge was concerned that one of the partners, who'd only announced his desire to buy the other one out at a very late stage of the process, he was concerned that was a ploy. It was a ploy to push up the price. He didn't make a sire's order. He made the usual order, but he built in safeguards for the other partner in case that was simply a ploy. So in essence, if a third party or whoever put in the highest bid wasn't good for the money, and that would include Tariq, I think he was the partner in question.
Just picking up what the judge said, can you say that your client can suffer financially because he's deprived of the chance to bid at a higher figure himself?
Yes.
I mean, he obviously can if his higher bid would force Matthew to bid higher. But on the face of it, if he simply pays more, he is financially worse off.
Well, that would be to ignore the fact that this is by now a valuable profit-generating business, a business which is in the year just before trial had generated profits of over £800,000. I don't know whether you try to interpret the schedule I put at the back of my skeleton, but what it shows is that it has become a very profitable business. It's carrying a lot of debt because of the investment in the new dairy, which of course has been supported equally by my client as well as by Matthew. But for each of them, there is the potential to carry on with this business, generating substantial profits. And they do have an advantage over a third party. The disadvantages of a third party, which is something which is relied upon by Matthew, are the advantages which Matthew and Daniel both equally share. And that is why it's a fair process, because if Daniel's evaluation of the situation is that it is worth him paying more than a third party, because he can benefit from those particular points, that's not unfair. If there's an unfairness, it may be that that Daniel has access to greater resources than Matthew. But in my submission, that's not a relevant unfairness. That is made plain by Lady Justice Andrews in Bahia. So the question is, what is a relevant unfairness? And the judgment is structured to establish an unfairness through the means of an equity. That is how the judge gets to the conclusion that he did. And although, well, there are 2 points to make about that in general. The first is that he does so by analogy with the doctrine of proprietary estoppel. And I challenge his decision on that, but not by challenge to the primary facts, but by the way that he applied the principle to those facts, essentially because there are things that he left out of account which he should have taken into account. But the second and broader point is that he justifies it by reference to matters of fairness, because Matthew is the deserving partner. And at the risk of jumping ahead, my lord, if you go in his judgment to the paragraph where he explains his decision, paragraph 392.
Sorry, paragraph?
It's paragraph 392, I think. Let me page 123. Paragraph 392, in responding to my bold assertion that regarding the potential unfairness of a sire's order to Daniel, where he sets out the equity, which the introductory words of the paragraph confirm are the exceptional circumstances which he finds triggers the sire's discretion. If you turn on to the second page, 5 lines down, he says, nevertheless, the court is entitled to consider his individual efforts in developing the partnership business, and to do so with particular focus upon a comparison with the business as it was at the partnership's inception and the relative efforts of the other partner in that regard. He's making what is, in essence, a moral judgment.
Or it could be reliance.
It may feed into reliance, but in my submission, it is also a moral judgment, because it relates to the effect. He put in all this work, and look, this is the effect of it. It isn't just did he do something factually in reliance. It had this effect, and he deserves to benefit from it because he's the person who brought that benefit to the partnership. My lord, that is signalled earlier in his judgment at paragraph 340, which is on page 115 in the bundle, where he summarises his conclusions on the facts. And the very first thing he says, paragraph 340, it is that Matthew has by far the stronger moral claim. And then at paragraph 341, he says that it is Matthew who deserves to be the successor to the farm. Now, in my submission, first of all, there's no authority which suggests that those are relevant considerations. But I would submit that in a partnership context, that's a very uncertain foundation for the exercise of the court's discretion. First of all, because it invites the kind of arguments which were put forward in this case. You haven't had to read the 112-page witness statement of Matthew, but dealing with many points about who was effectively the better farmer and who did what, this, that, and the other. It's not a sound foundation for a principle of this nature in a it is at its heart a commercial relationship. But the other difficulty with it is that it leaves out of the account the position of the other partner, and that's particularly stark in this case. Yes, it is Matthew who is the driver of the partnership business and the expansion of the dairy, but he can't do that without Daniel. He can't do that without Daniel's money, and he can't do that without Daniel backing the investment in the dairy in 2013 on which this case hinges. And if there's any doubt about that, that is demonstrated by the events of 2021, when the fallout between the brothers was triggered by the opportunity to purchase the neighbouring farm, the Ely farm. That's Matthew wanted to buy it. The evidence accepted by the judge was that Daniel originally wanted to buy it, but then changed his mind. It was that decision which triggered Matthew's realisation that the partnership had to come to an end, and led ultimately to the dissolution of the partnership. But he needed Daniel then to be able to continue to expand the business. He needed to carry on riding on the back of Daniel financially, so to speak. Matthew's case is that the dairy is his baby, but in a partnership situation, it takes two people to make a baby. There are two partners. It couldn't be made without Daniel's involvement. Daniel worked for the partnership throughout. The partnership carried on at the place where he's lived all his life and still lives. So for the court to be indulging in making a moral judgment that because of the way that they structure their affairs, and Matthew is the driving force, that he's the person who then has a greater moral right to buy out the other, in my respectful submission, is wrong. That cannot be an appropriate basis for the exercise of this particular jurisdiction, particularly not in circumstances where that other brother has the resources to pay more. The fact that he benefits, or the fact that he's prepared to pay more, is essentially establishes what the market value is as between the brothers for what the benefit he obtains by buying out his brother. So to come back to where I started on this point, the fact that one brother can pay more than the other brother and is prepared to do so, even if it is more than a third-party purchaser is able or prepared to pay, is not a factor which should have been ruled out. But that is what the judge did. And I would also assume that there's no principal basis for saying that he could do so as a form of a sort of moral reward for Matthew. Well, the fact, I don't know if would be in dispute, but the fact that it's the financial fairness of the outcome which should be the guiding principle is something which is, in my submission, clearly established by the judgment of Justice Andrews in here. in the authorities on that is at item 3 in section D.
Just before we look at that, can I go back to a point my lord made earlier? I find it easier if you put some hypothetical figures in there. Suppose the evidence was that the most of the third party purchaser would pay was £5 million for the whole.
Yes.
Suppose Matthew, he's prepared to pay 3 million, but that's the most he's prepared to pay for it. So to him, it's worth 6 million.
Yes.
But to Daniel, he's prepared to pay 3.5. So to him, values it the whole farm at 7 million.
Yes.
Now I can see, as my Lord Justice Lewison said, that if you get to a stage of ordering a buyout, the buyout should take account of the fact that for Matthew the farm's worth 6 million, so that Daniel should receive at least 3 million, not the 2.5 which he would receive on the open market. I can see that argument, but that's a question of how much one might pay. But what I don't see is how the fact that Daniel's prepared to pay 3.5 million makes it financially unfair for him to only receive 3 million, because he would never actually pay 3.5 million if there was a competition between the brothers. He'd pay 3 million and a tiny bit. And isn't that the judge's point about the tractor? The fact you're prepared to pay more than is necessary doesn't increase the value to you of your interest.
Well, whatever you pay for it doesn't have any effect on its value. Its value is its value to you. I accept that point. But how you assess the value to yourself, you test your own mettle by seeing how far you're prepared to go in order to buy the asset. So in your lordship's example, the outcome, if Daniel pays more than Matthew, even if it's only a small amount, is still, it's not financially unfair. It may be only a small difference, but it is the maximum amount which can be achieved. And of course, the process which your lordship postulates is one in which it is assumed that that a third party comes in at a lower number. And the problem with making a buyout order in which that possibility isn't explored is that we just don't know if that is the actual position. I would accept that one possibility is that a lower offer would be received from third parties than the amount of the valuation by the expert, and therefore it would then become a bidding war effectively between Matthew and Daniel. But that's the nature of a market. It may be a small market, it may just be two people, but a battle of bids is always won by the person who's prepared to go a pound more. That's the way the market operates, and that isn't unfair. Even that process drives up the price, and Matthew is properly compensated by the fact that the price that his brother is prepared to pay is A, higher than he's prepared to pay, and B, higher than a third party is prepared to pay. So it is a financially fair outcome. What it does is it maximises the value, it maximises the amount that the selling party receives. And the concern in the authorities, I would suggest it is to ensure that it's the selling party who is properly protected. Now, if there was any problem about selling a farm, some of the authorities deal with different types of partnerships where there is some difficulty in selling the assets of the partnership, or where a sale of the assets of the partnership isn't likely to produce very much. I think Hamilton Bealey is an example of that, particularly a services partnership, for example, where the value lies in the work provided by the partners themselves. Then, in those circumstances, a sale may not be the appropriate course, particularly if for example, there is an agreement in place between the partners, as there was in Mullins, which dictates what should happen if a partnership, if a partner is retires, or if the retirement provisions are exercised properly. But this is not that case. This is a farm. It's a farm in which the investment is in buildings. The big investment in 2013 was in buildings and equipment. It's the buildings and equipment which provide the foundation for the partnership to earn the large profits which it does. And it's the value of that to the brothers as well as to the outside world, which is at the heart of this.
Thank you.
So and just to make it absolutely clear, I didn't take any issue with the approach taken by Mr. Townsend. He gave what was no doubt a perfectly proper valuation on the basis of his instructions. He was simply instructed to value the farm as a farm, and that's what he did. And he said quite fairly that he didn't take into account the profits. He wasn't instructed to do so, and therefore he didn't. But he accepted the possibility that the profit-generating potential of the farm, because of its exceptional nature, because of this investment in this the equipment and the new dairy, was something which might influence a potential third-party purchaser. And that was the only point I was seeking to take from the valuation evidence. The judge approached it on the basis that we should have asked for a different type of valuation. We should have asked for an EBITDA type business valuation. But I wasn't seeking to achieve that point. All I hoped to achieve was to establish that there was a realistic possibility that somebody else might offer more than if it was valued on the basis which he'd valued it, which was not taking into account its exceptional capabilities of producing remarkable profits for a dairy. And that's what I did establish. I respectfully submit from cross-examination, and that's all I needed. So I would submit that much of the judgment is respectfully a bit of a red herring when it deals with those points. I was going to take you to the passages by here where Lady Justice Andrews expresses, in my respectful submission, correctly the object of this whole exercise being financial fairness. And the first mention is in paragraph 2 on page 106. Where she says, and see by way of introduction, in the absence, this is the final sentence of that paragraph, in the absence of agreement, the court has to do its best to achieve a fair outcome, which involves seeking to maximise the realised value of partnership assets for the benefit of all the former partners. Then at paragraph 27, on page 111, paragraph 26, she observes there's no absolute rule that partnership assets should be sold on dissolution. And then at 27, she explains the rationale underlying the normal practice of sale on the open market. Usually be the best means by which to achieve a full and fair value for the partnership assets. The partners can test the market with competing bidders in just the same way as they would if they were selling their own property. If one of the partners has a particular interest in acquiring any of the partnership property, an open market sale will ensure he pays a fair price for it. And that's the point I've just been making. And again, at paragraph 45.
Well, don't we need to look at the qualifications of that statement in paragraph 28? There may be cases in which an open market sale would not be the best means of achieving full value, well, that goes to maximising value,
Yes.
or would be unfair.
Yes. But the unfairness that she refers to is, well, she uses the example of Hammond and Brearley.
Well, she makes the point about unfairness or injustice at a number of different places in the judgment. And we start at paragraph 6. there may be circumstances in which realisation of the assets in the open market is not feasible or would produce an unjust outcome. Which
Yes.
starts that discussion. And then at 28, he go and talks about unfairness. Sorry, you wanted us to go to which paragraph next?
I was going to go to paragraph 45, my lord. Page 116, after going through the examples which he sets out, all these are examples in which a sale by auction would not serve the interests of justice. It would not maximise the value of the assets, or even if it would unduly favour one of the parties or unduly disadvantage the others. Now those words, unduly, in my respectful submission, indicate unduly by reference to the financial benefit of doing so.
Why?
Because how else could it unduly favour a party other than by reference to its...
But she's envisaging that the sale by auction would maximise the value of the assets, even if it would. So that's a maximum value. But even so, she says, it might unduly favour one of the parties or unduly disadvantage the other. So that's even if it does maximise financial value, isn't it? Doesn't that what that sentence means?
Well, it's the words, how can one of the parties be unduly favoured? What is it that could, in what respect could that party be unduly favoured by that process?
Well, I know that's a rhetorical question,
Yes.
but it might be answered by saying that there might be something other than maximising the value of the assets, which would amount to unduly favouring one party or disadvantaging the other. I.e., not financial unfairness, but some other kind of unfairness.
Yes. The examples which are given don't, in my respectful submission, establish unfairness which doesn't relate in some way to the value of the business. That's Hammond and Bealey itself was a case in which it was envisaged that a sale wouldn't benefit anybody because of the nature of the sale. And as I say, Mullins and Norton is the same. It should also be borne in mind that in those cases, both of the parties, certainly in Mullins and Norton, had indicated that all they wanted was a financial outcome. The partner, the departing partner, or the ousted partner in Mullins was made it plain that he simply wanted the amount standing to his capital account to be paid. It was a financial matter. What he wasn't seeking to do was to compete for the right to buy out his fellow partners. There isn't, in my submission, an authority in where the court considers the fairness of the order, that it is something which is non-financial, it is the decisive factor. The judge referred to the decision in Anselm, which I think is the only decision which refers to an equity as such. That
That was Mr. Justice Hart's decision, was it?
that's correct, my lord. Yes, which is I think it's the first item in
Yeah.
The section D of the authorities bundle. In that case, it's another case between two brothers, and Ronnie, one sees at page 69 towards the bottom, mark 5th. Ronnie alleged, on the basis of some discussions, that there was an agreement with his brother. Ronnie should retire from working for the Hobbs Company and shouldn't become a shareholder therein, but that all the assets of the property partnership should belong to Ronnie, absolutely, on the footing of the partnership being dissolved. It was on that basis that he asserted that he was the owner of those properties. And if one then moves on to page 73 in the bundle, where Justice Hart summarised the applications before him, first paragraph on that page, he set out Ronnie's overriding concern that these properties should be preserved so far as practicable pending trial of the action, so that if at the end of the day his claim to be entitled to them pursuant to the July agreement is vindicated, he will be able to enjoy them in specie. So that's what he was seeking. He was seeking, when he was claiming that he owned the properties. Yoram, his brother, was seeking an order that the partnership properties be sold. Over the page at page 74, where Mr. Justice Hart considered the question of whether there was a serious issue to be tried in what was an interlocutory application. He explains about 7 or 8 lines down. On the other hand, it's also reasonably clear that at least in relation to Ronnie's future association with and interest in the Hobbs companies, the brothers were then seeking to arrive at a final agreement which would involve Ronnie giving up his claim to any equity in the Hobbs companies. So on the face of it, the issue in relation to equity was about something of value. Then at the end of this particular section, where he's considering the points on the following page, in the first, the top of the paragraph which stops, top of the page, and the paragraph which starts on the previous page, first full sentence, he summarises position that if Ronnie's account be accepted, Yoram has deliberately manipulated himself into a position whereby Ronnie has been deprived of a just entitlement to an equity participation in the Hobbs group of companies. And then in the following paragraph, summarising the position, he says, without a trial, I don't find it possible to form a view as to which case has the greater merit or is the more likely to be accepted. I accept that Ronnie's case in relation to the July agreement, that's the one that he was an owner of the properties, is a difficult one, but it is not possible to conclude on the present evidence that it's not arguable, nor can I be at all sure that even if Ronnie doesn't succeed in establishing the July agreement, the court will not conclude that the equities are nevertheless such as to require Ronnie to be given an opportunity of purchasing Yoram's interest in the disputed properties, rather than as to dictate their sale to a third party. In my respectful submission, what one can glean from this judgment is that the matters which Mr. Justice Hart had in mind were essentially financial ownership matters. The equity appears to be the equities in relation to various types of property, physical, real property, but also an interest in the company, or shares in the company. That if that's the basis for an equity, and it is the way, in my submission, that Judge Russen approached it.
So I'm not quite sure that I understood what you're saying, Mr. Justice Hart meant by the equities are nevertheless such as to require Ronnie to be given an opportunity of buying. What equities?
Well, we don't know precisely what equities, but what one can glean from this judgment is that there is a claim to an equitable interest in the companies, the Hobbs companies, as they're described.
For the disputed properties, I thought, were the properties that are referred to towards the top of page 69, namely that Yoram and Ronnie were partners in a business of investment in commercial and residential properties, with Ronnie acting as the active managing partner. That's the partnership.
Yes, it is.
Nothing to do with Hobbs. Hobbs is part of the wider allegation of the settlement. It's not. Hobbs is not a partnership asset, if I've understood correctly.
Yes, that's my understanding.
So when Mr. Justice Hart talks about the equities, he's talking about something to do with the partnership, which was the business of investment in commercial and residential property.
Well, he's making that point in the context of a number of disputes which are going on between the parties, which would no doubt be dealt with at the trial of the matter. He decided to hold the ring, as it were. One can't say, there's no indication in any of this that Ronnie was seeking to establish some kind of different equity on the basis of him being a more deserving partner or anything along those lines. What one can glean from this is that there were a number of moving parts, which included claims to equities in other types of property, or asset, I should say. What it doesn't suggest is that there's a non-financial component to the equity, and that's what Judge Russen took from this decision, that equities, reference to equities is broad enough to bring into play non-financial equities in circumstances where he made plain that the equity that he considered was relevant was one which was not one that was capable of valuation. It wasn't a financial, had no financial value. Well, can I turn to paragraph 191 of Judge Russen's judgment? Where he sets out the points that he gleaned from the authorities. Page 87.
Yeah.
First of all, he doesn't say in terms that the purpose of the objective behind the procedure on dissolution of a partnership is to maximise the financial outcome for the partners. subparagraph 4, he says that the nature of the discretion and the purpose to be served by its exercise, that of achieving justice between the partners on the facts of the particular case, means that the categories of case suitable for sire's relief cannot be exhaustively identified. He doesn't go on to consider what achieving justice means in the context of a partnership dissolution.
Do you quarrel with the proposition? I mean, I follow what you say, but he says that the categories can't be exhaustively identified.
I don't quarrel with that proposition. But I do quarrel with the point that he makes in the final sentence of this paragraph, where he says, the test is whether, as an exception to the normal rule, a sire's order can be justified on the basis that it would serve the interests of justice on the facts of the particular case. So, in my submission, that is circular. The sire's jurisdiction is that in exceptional circumstances, the court can choose not to make the usual order. But in this, what the judge is saying is that one first considers the justice of the case and then decides whether or not that's an exception to the normal rule. And that begs the question of what the interests of the justice are in the first place. So it doesn't assist the court. And in my submission, it is a circular point. What essentially it does is it invites the court to find whatever it considers to be relevant to the justice of the case. And then if it concludes that the justice of the case merits a buyout order, then it will make that order. But then there's the problem with that is it doesn't focus on what the purpose of the process is trying to achieve. What is the underpinning principle?
So in effect, I think what you're saying is the last sentence of that sub-paragraph is pretty much what Mr. Thomsall did in the Bahia case, which this court said was wrong.
That's exactly my point, my lord. And I was going to go to the paragraph in my learned friend's skeleton argument, I think it's paragraph 20, where they've said that what he did was to treat himself as having an overarching discretion, whereas that is not what the authorities show. The authorities show that there is a discretion, but it must be operated, it must be applied in a principled way. And a principled way, in my respectful submission, must be one which builds upon the authorities showing how the court has dealt with it in the past, but also having at least one eye firmly on the point that it's a partnership and the object is to maximise the financial position for the
But
parties.
I think you would probably accept, would you not, that if the partners had agreed in a contractually binding way that one should be entitled to buy out the other, the court would give effect to that agreement,
Yes.
whether or not it maximised the value of the assets. So we are one step away from that, in which the judge has found that Daniel made a promise to Matthew that in the event that he left the partnership, Matthew would be entitled to buy him out, and Matthew acted on that promise. You say that is just to be left out of account completely?
I say that if well, I'll deal with that in relation to the proprietary estoppelish equity, which is what the judge
Yes.
says. I say my primary argument is that is wrong as an approach, because essentially if there is an agreement, the court gives effect to the agreement. It almost ousts the discretion of the court.
Well, there's a contract. The court must
Indeed,
enforce it.
and that's how this case was originally pleaded.
Yeah.
But if it is not a contractual situation, then in a sense, your lordship's point begs the question: a promise is made, and yet it's not a contractual promise.
Mm.
So, in my submission, that isn't something which should engage in the way that the judge says it does.
So, why not? You say proprietary estoppel or similar is not established here anyway.
I do say that, yes.
But leave that aside for a moment. Suppose it were established. Proprietary estoppel could give you the farm. Why shouldn't the same reasoning have the potential to say, oh, okay, the right order is the sort of order the judge made rather than an ordinary order for sale? I mean, what if proprietary estoppel can give you much more? Why shouldn't it be capable of giving you the sort of relief that the judge thought was appropriate?
Right, I think I would accept that there must be circumstances in which something can arise, in which
Sorry, there must be circumstances in which.
If a proprietary estoppelish equity was established, that would be something which the court could take into account. But it's still something which has to be measured against the other matters in the case.
So that's a bit funny too, because guest and guest says you get your expectation interest, more or less. If you get your expectation interest, you're not measuring against other things, particularly.
Well, can I approach it in this way? What I'm going to do is to look at the way that the equity is expressed, and I take on board your lordship's point. The way that the equity is expressed in this case is one which, in my submission, is problematic. That's the paragraph that we have looked at.
392, is that?
It is, my lord, yes.
Yeah. But just one other point, I might put this to you. Isn't the whole relationship of partnership imbued with equitable principles?
Yes.
Yeah.
Before we go to 392, you took us to the end of 1914, reference to serving the interests of justice. And you said the problem with that is it's too open texture. Those weren't your words. That's effectively what you said. It doesn't give you any parameters for it. But as I read it, the judge does try and tease out what he means by that in little 5 and little 6. So little 5 is dealing with contractual intention. And then little 6 is dealing with the sort of thing we've been talking about, proprietary estoppel type arrangements. Is he wrong at this stage? He's not dealing with the particular facts, he's dealing with the principles. Is he wrong in what he says in little 5 and little 6?
I don't take issue with 5 in the sense that if there's a contract in place, then that must bite. In 6, well, this is why I was going to go to the equity itself, is that it depends in my submission. If it is true that a proprietary estoppelish equity is the basis for an equity or basis of an exception which could justify a sire's order, that is something which it needs to be it needs to be a principle which can be properly evaluated and tested against. It's one which has to be carefully defined, and obviously one which then would have to be applied carefully on the facts.
Yes.
Which was, sorry, Neil.
Right, going to 392.
392, well, yes. This is the equity which he considers would give rise to could amount to an exceptional circumstance for purposes of a size order. And my first simple point is that it's a very long and complicated equity. It's said to derive from proprietary estoppel, to be analogous to proprietary estoppel, and yet there isn't any reference in this to unconscionability.
Well, doesn't Guest and Guest tell us that the unconscionability lies in reneging on a promise where the promisee has acted to his detriment in reliance on the promise?
Yes, but it's important in my submission if there's an equity which is going to be the basis for an exception, is that it's one which must be one which can be properly measured and tested against. And the way that he approaches it in this paragraph is simply to refer to it being unfair and inequitable. He does so also in circumstances where, as I've already pointed out, that it involves a moral judgment.
Yeah.
So I say that it's an uncertain equity. It isn't one which is established in any previous authorities, and it, in a sense, is unnecessary, because if the parties have an agreement, then effect can be given to that. But otherwise, we have this very long and complicated equity, which is difficult to apply. And I would submit, and I'll move on to the way that he concludes that the equity has been established. That is a particular problem in this case.
Can we just look at it for a moment to compare it with conventional proprietary estoppel? The first sentence, partners have shared an understanding and a partner has devoted himself accordingly to the firm's business and development. So that sort of fits proprietary estoppel?
Yes.
A little later in the paragraph, he says the understanding and reliance upon it gives rise to an equity. 8 lines down,
Yes.
top of the next page.
He says you have to take account of the fact that there's a shared endeavour, and he says the court is entitled to consider individual efforts. So that's trying to balance the fact that the partner will be trying to work for the benefit of the partnership as a whole, but nevertheless I suppose you can infer that he's relying on the understanding. So that would sort of fit proprietary estoppel.
Yes, the difficulty of applying proprietary estoppel is that whereas in the classical proprietary estoppel case, one party is making assurances or whatever means that the other party relies upon, they will get something. They will get a share in the property or the farm or whatever it may be. In a partnership situation, the partners are dealing, well, they are both owners of the asset in question. And that makes it far more difficult to disentangle what it is, which can amount to the basis for an equity.
Why?
Because they both have a joint and the same interest in the partnership succeeding. And
So
that's the problem.
If
Sorry.
people are contemplating going into partnership with each other, two people, one says to the other, well, I'll only do this if in the event that there's a dissolution, I can buy you out because I'm not spending my life working in a business which is then sold to a third party. And then in reliance on an understanding that that will happen, goes into partnership. Why is that difficult to apply?
Well, in those circumstances, there would be an agreement which could be enforced. The difficulty in a situation, and I would submit that this is a case which demonstrates that, where a mere assertion that at a future point in time I will leave the partnership and you will buy me out, that creates a difficulty because the actions of the parties can be explained by simple reference to the fact that they are partners.
Moving to the facts now,
I'm
I'm just trying to see what the principle is that you're saying that the judge got wrong.
Well, I'm saying that the principle, he sets out a principle which is, it's, first of all, it is basically too complicated, and it brings into play this moral judgment aspect of it.
Yeah.
If you tease that out and you go back to the fact that this is a partnership relationship in which all the actions of the partners can be explained by the fact that they are partners, then to be introducing an equity which is complicated and uncertain is, in my submission, it's wrong. There's no authority to show that that's the case.
I mean, I see the complication, and maybe that arises because the fact situation that is envisaged, as you say, where it's a partnership. But where do you see the moral judgment coming in?
In this,
In the formulation of paragraph 392.
on the second page, my lord, nevertheless, the court is entitled to consider his individual efforts in developing the partnership business, and to do so with a particular focus upon a comparison with the business as it was at the partnership's inception and the relative efforts of the other partner in that regard.
So you say that isn't merely trying to discern reliance and detriment, it's something more than that.
Yes, I do say that.
Is that right? Because when you read the paragraph, I understand if you take that sentence out and isolate it, it's as if the court's making what you call a moral judgment. But when you read the paragraph as a whole, it starts off by saying you have understanding and you have reliance. And then at the bottom of page 123, he looks at whether reliance is detrimental. And as you pointed out, the problem is if partners work in a business, how can you be satisfied that's detrimental reliance? Because it's their business and they take profits out of it, so you'd expect them to work in it anyway. And it's at that point that he says, but you can take account of the fact that you've devoted your individual efforts to it and the relative efforts. So that looks to me as if it's all part of his analysis of how you characterise the representee's actions as constituting detrimental reliance, that being one of the things you need to establish this type of equity. That's how I read it anyway.
Well, in my submission, that isn't the correct reading of it, or at least if it is, it's not clear from what the judge says. Bearing in mind the wording in paragraphs 340 and 341, which I've taken you to, about Matthew morally deserving this. It seems that what the court is taking into account, or what the judge was taking into account, in his individual efforts, is saying that he deserves it. He deserves it.
Can I just take that a stage further? The judge goes on to say an order for sale would be unfair and unjust. Now, that might be said to correspond to unconscionability, which you said he hadn't taken into account. But then he goes on to say, well, in considering what's fair and just, we can take into account impact on third parties and so on. And I think you would say there, well, where does impact on third parties come into this?
I do say that. That can't be the basis of the equity. What he also does is that he ties the equity into the valuation exercise. And he says the court is entitled to act upon the equity where expert valuation evidence supports the conclusion.
But that might be said to be an aspect of unconscionability. I mean, the person who has acted on the understanding to his detriment can fairly say the other partner should be stuck with that if you've got reliable valuation evidence.
He says, the court may act upon the equity despite any suggestion by the second partner that he'd be willing to pay more for the first partner's share than is offered in return, and notwithstanding the prospect that such a sale might have produced a greater financial return for him than that indicated by the valuation evidence accepted by the court. So he seems, I respectfully submit, to be tying the equity to the valuation process. Really, if there's an equity, it shouldn't matter what the valuation position is. But essentially,
Just unpack that. Why would it not matter what the valuation position is? If the equity established,
yes,
in principle, is that one partner should be entitled to buy out the other, somebody's got to fix a price. Why should that not be a valuer?
the equity is one which ousts my client's right, as it were, right in inverted commas.
Yeah, it
seek
justifies, so the judge says,
Yes.
a departure from the normal practice.
Yes.
And the equity that he finds established is that Matthew would have the right to buy out Daniel.
Yes.
Now, having reached that point, we've got to put a price on it.
That's correct, my lord. I would accept that as a point. But it's by including it within this description of the equity and the explanation of it, it's one which the existence of the equity is sort of is distorted in a sense by the end goal that the court is seeking or is driving towards. The equity itself should be separate.
Yeah, but isn't he now dealing with the remedy when he talks about the court being entitled to that? This is how we satisfy the equity.
That's correct, my lord. But he deals with it in terms of the exceptional circumstances. So he's tying the equity in with the valuation.
Yeah.
I'm going to move on then, if I may, to the point that the judge in my submission was wrong. If I'm wrong on that point, and the principle that an equity can found or can be the basis for an exceptional order, then I submit that he was wrong to find that it was made out on the facts of this case. And I don't attack any of the judge's findings of primary fact. My case is based upon his findings of primary fact and the evidence given by Matthew and Haley.
So we're on to your ground 2.3, are we? I'm just looking at your ground here. Ground 1 is that the judge was wrong to find the facts of the case was exceptional. So that's I think what we've been dealing with. Is that right?
It is, my lord, and also sorry.
Ground 2, you say no. The ground 2, 1 and 2.2, you say the nature of the equity was unclear and so forth. That I think.
Yes.
So now we're on to your ground 2.3. The equity was not established on the facts.
Yes,
Is that right?
That is correct.
Okay.
And so far as that is concerned, as I say, I'm not attacking any of the judge's findings of fact. But I am saying that he left out of account things which he ought to have taken into account in deciding whether or not the equity was established on this case. And my lord, I respectfully rely upon your own summary of the principles in relation to corruption, estoppel in Davis and Davis, as a summary of the relevant principles. The first point relates to the assurance itself, or the understanding. My lord, it's essential in a proprietary estoppel case that context be taken into account. In my submission, despite the fact that I pointed this out in my closing submissions, this is a matter which the judge failed to take into account. The context in this case is very important. First of all, to understand what it is that it is said that the understanding was. What were the words which gave rise to that understanding? And then whether or not it was relied upon, and if so, whether the reliance was reasonable, and then if it was resiled from, whether or not there was unconscionability in those actions. Daniel. Well, I think it's appropriate to go to the particulars of claim, the amended particulars of claim. First of all, just to place this into context. Those are at briefly already, but at page 158. In the core bundle section C. what he says in paragraph 8 from the fourth line, Daniel said that he was under pressure from Georgina to move from the farm to Taunton, where Georgina's family is based. Daniel said he would one day leave the partnership, and that Matthew would at that point need to buy him out. No particular date was specified, but Daniel made it clear from what he said that his own involvement in the partnership business was always going to be time limited. It's important that his case is founded on this single conversation. Paragraph 30, he sets out his reliance on that conversation. So again, that emphasizes the importance of the conversation to his case. And that's important because, of course, that's the date of the massive investment in the new dairy. Well, in Matthew's evidence, he repeatedly stated that what was actually said to him by Daniel was that one day he would have to move to Taunton, and Matthew would have to buy him out. In the supplemental bundle, I can invite you to turn to the transcripts in section E, page 175.
One 175 in the numbering in the bottom right hand corner.
I'm sorry, yes, the paginated. Sorry, it's in section E. It may be the first.
Yeah, this is proceedings day 1.
It is.
Yeah,
my lord. So page 37. Line 5, I'm asking him about the conversation. Conversation which you said you had with Daniel was one which was about Daniel having to move to Taunton because Georgina insisted that he should. Yes, Daniel came to me, he was upset, or as upset as he gets. Daniel said that he was going to have to move to Taunton. He said that one day I would have to buy him out. He says that again and again. I won't take you to all of them, but while we're on that page, on page 38, at line 14, Daniel's words, one day he will have to move to Taunton and I will have to buy him out. One day I will have to buy him out. Because he would move to Taunton? Yes. He hasn't moved to Taunton, has he? No. Page 39 again, line 4, Daniel told me that one day I would have to buy him out and he would move to Taunton. And the next page, page 40, line 8, Daniel wasn't threatening to do anything. He was under pressure from Georgina to move to Taunton. He was making me aware that one day he would have to move to Taunton and I would have to buy him out. And he repeats that again at line 19 on that page. Whilst we're on the same page in the bundle, but page 42 of the transcript, he confirmed again at line 6 that Daniel was upset. That is what he said. Over the page, my lord, page 176, this is actually me quoting from Matthew's witness statement at paragraph at line 3.
So where are you?
I'm sorry, it's page 177, my lord. Sorry,
7-7.
I get it wrong.
Manuscript page.
It's page 44 of the transcript, and it's
Yeah.
line 5. Sorry, look. Daniel told me that he was between a rock and a hard place with Georgina. Daniel said he believed that Georgina would leave him if he didn't move to Taunton.
Yeah.
Daniel didn't want the embarrassment of a divorce. And his evidence continues like that. I'm not going to take you to every reference, but if you turn on, please, to page 179. Bottom left-hand corner, page 53, line 5. I ask him, you're saying that this conversation to you, Daniel, came to you, he was uncharacteristically upset. Is that what you're saying? And the answer, I don't think he was happy at the time about going to Taunton. Georgina was presumably applying pressure on him to move to Taunton. We were taking on debt to buy Willie out. Willie's their brother, you may recall from the judgment. Or had just taken on debt to buy Willie out. And then at the bottom, as it's relevant to the other points, the very final line confirms that at that date, in 2005, 2006, that the new dairy wasn't on his radar.
Yeah.
Now, the significance of those points is that the assurance, the understanding, which is said to give rise to this equity, is based upon that single conversation. And his evidence is very consistent that that Daniel was upset because of the pressure he was under from Georgina. Daniel would have to move to Taunton, and that would, and Matthew would have to buy him out. He didn't say quite the way that it's put in the particulars of claim that he would leave the partnership. It's very specific to going to Taunton, to leaving Taunton under pressure from Georgina. The point I've made in my skeleton argument is that at this point in time, Daniel was recently married. Daniel and Georgina had their first and only child, and Georgina was effectively commuting back to her family business and staying there 2 nights a week, something which she continued to do. So this is relevant context which would explain why he was upset at that particular point in time, and why at the outset of the relationship of the partnership between the two of them, taking on some debt to buy out Willie's share, that he would be warning Matthew that at some point Georgina might force him to move to Taunton.
So I think there are 3 points that you're really making here, aren't there? One is there's only one conversation. This is not
Yes.
a sort of Thorner and Major type
Absolutely.
case where for years and years and years the promises that one day all this will be yours that have been made.
Correct.
The second is that this was not any sort of unconditional assurance that if I go for any reason, you can buy me out. It was linked to if I have to go to Taunton.
Yes.
And the third is that because this was said by Daniel when he was upset, this was not something that was reasonable to rely on anyway.
Yes, and
Those are the 3 points. I
Well,
think.
there's a fourth point as
Fourth
well,
point, right?
which is the timing of the reliance, if I can put it like that, or the way that it's relied upon.
Well, the reliance is said to come some years later in 2013 when the dairy is built, but that's not what the judge finds. The judge finds, I think, that it was relied on because Matthew devoted himself to the farm, quote, accordingly, unquote.
Well, the pleaded case starts with the, which is why I took you to the particulars of claim. It links the investment in the dairy, and it is the investment in the dairy which is the thing which Matthew relies upon for his case. That's his baby. That's why he wants to keep the farm. So the context was important. The fact that he was upset was important. The fact that that is an unusual thing was important. And the words he used, first of all, they're not actually an assurance, or even, dare I say it, an understanding. They are a warning. They're a warning, not a threatening warning, but a warning. I may be forced to move to Taunton, and you'll have to buy me out. And in sorry.
I mean, I follow how you put it. Is how you put it consistent with what the judge found in paragraphs 348 to 350? If it isn't, do you attack those findings? But you.
He doesn't deal with the context at all.
When you say that, that suggests that you're taking issue with his finding because he's failed to take something into account. Whereas my understanding was that you weren't taking issue with his findings of fact, but rather making other points.
I'm not taking issue with his primary findings of fact, and by that I mean who said what to whom. But I do take issue with the fact that he failed to take into account the context, because the context is relevant to understand what it means.
I think you are quarrelling, aren't you? The judge's finding is that Daniel said to Matthew that, quote, one day, unquote, he would have to buy Daniel out of the partnership. Whereas you are saying that it was only in the event that Daniel moved to Taunton under pressure from his wife that would happen. It wasn't just one day,
Well,
it was a specific set of circumstances.
Can I invite you to turn to paragraph 220?
Just before you do that, in 350, that looks like a finding that Matthew expected as a result of the conversation that he would be entitled to buy out Daniel when the partnership comes to an end. Now, is that a finding of primary fact that you don't attack, or is it something you do attack?
It is. It's something which I attack as something which derives from a primary fact, but then I also attack it in a separate way, which is that that conversation could have given rise to a reasonable reliance, or that it would be was reasonable for Matthew to have relied upon that conversation in the way that he says he did.
That suggests that you do two things. You say that the judge could not properly conclude that Matthew did, as a matter of fact, expect that he would be entitled to buy out Daniel when the partnership came to an end. And secondly, you say that's wrong and he did expect that. It wasn't reasonable for him to do so, given the context of the conversation. Is that
Yes.
right? Yes.
Yes.
No, he wanted us to go to a different paragraph, I think.
I was going to go to paragraph 220.
220. How are we doing for time? It's now 12:15.
Yes, the agreement was that I would finish by 10 to 1. So
Right.
this is I will focus on this part of my case, and I'll have to work on my.
12:40.
12:40,
Sorry,
12:40.
12:40. Forgive me.
Yeah. This is the judge recording Matthew's cross-examination.
Yes. the evidence he gave was that it all related to Taunton. I would have to buy him out. So the context was important.
Yes.
So it may be on reflection, my lord, and in light of your lordship's point, that I am attacking a primary finding of fact, paragraph 348, in that the evidence given by Matthew was consistent, that it related to Daniel moving to Taunton. The omission, if I can put it like that, in paragraph 348 is that it doesn't tie the leaving the partnership to the moving to Taunton. It's the moving to Taunton which is the crucial point. So if the finding of paragraph 348 doesn't deal with that particular point, then he's left out of account a relevant and in my submission a crucial matter, because that explains what Daniel was saying at that particular point in time. He doesn't deal in his judgment anywhere with the context. He doesn't address it other than to mention in passing that paragraph 349, that the conversation took place after Daniel had told Hayley that Georgina didn't want to live at Wickham and that he would have to move. But he doesn't place that in context. He doesn't consider the actual position of Daniel and Georgina in relation to their circumstances. And then, very importantly, he then doesn't go on to consider the submission that I made, not only that I made, but that is also pleaded in the defence, that if that was the impression that, or the understanding which Matthew had gained from that conversation, that there must have come a point at which that understanding was no longer reasonable. And I put the case on that it must have been in 2008, because by that point the crisis had averted, the crisis of Georgina threatening to leave Daniel had averted, and she and Daniel had established a modus vivendi. Their son was at school in Taunton. Georgina was continuing to work at home and stay at home near Taunton. I say at home, that's a slip on my part, at her parents' house in Taunton, while she was continuing to live at Wickham and Daniel was continuing to live. So there must come a point in time at which it ought to have been evident to Matthew that the crisis had gone away. There is then a significant gap between the events of...
Do you mean that it was unreasonable for the understanding to continue rather than for the reliance to continue?
Well, both, my lord, yes. The understanding, it was no longer a live possibility. So the understanding was a very specific understanding in 2006 in relation to the circumstances at that time. They'd just taken on debt to buy out Willie. But that understanding, that wasn't a continuing situation. It was something which the circumstances had changed. But if I'm wrong on that, it nonetheless there must come a point at which to base one's future on a single emotional conversation of this nature in very specific circumstances itself must become unreasonable. And that's a particularly stark point in this case, where in 2013, the new dairy project is undertaken. Huge amounts of money are borrowed from the bank, and both brothers take on those liabilities, and although it's accepted through Matthew's efforts, invest significant sums of money into the partnership. the basic point is it is a world away from the situation of the emotional conversation back in 2005, 2006. And the difficulty with the judgment is that the judge simply doesn't address that point at all in his analysis of the facts or the way that it works. He didn't address my point about 2008. He didn't address the point about the situation about what would have been apparent to Matthew in 2013. He also didn't address the point, and this comes into unconscionability, in my respectful submission, that unconscionability has to look at the actions of Daniel in reciting from a promise or agreement or understanding. Daniel takes on liability just like Matthew in 2013. There's no assessment in the judgment at all of the way that any of this impacts upon Daniel, or how it can be said that what he has done many years later, when his brother decided in effect that the partnership should come to an end, how it can be unconscionable in those circumstances. And his brother has said nothing to him about this, other than to have a few brotherly rows. In circumstances where he accepts in his evidence, where Matthew accepts in his evidence that Daniel saying to him, this is after the dairy had been constructed, they have a row with Daniel saying, go on then, you have to buy me out, knowing that Matthew didn't have the finances. So the judge, he doesn't address the context in which the conversation took place. He doesn't consider the meaning of the conversation against that context. He doesn't consider the reasonableness of the reliance. He doesn't consider whether or not it's still reasonable for the reliance to be for there to be reliance in 2013. He doesn't deal with the unconscionability. He also doesn't deal with the point that the pleaded case is that Matthew's involvement. Matthew understood that Daniel's involvement in the partnership was only going to be time limited. And he doesn't deal with that in relation to two particular points, which again were raised in evidence, in cross-examination, and in my closing submissions. One of which is the conversation which, on Matthew's evidence, he had with Daniel in about 2015, where they considered, or he asked whether Daniel would agree that the shares of the partnership would be split 3 ways between their children, Matthew having 2 children and Daniel having 1, rather than Daniel's child having a full half share. That would be wholly inconsistent with Daniel's or Matthew believing or understanding that Daniel's involvement in the partnership was time limited, which is the way that it's pleaded in the particulars of claim. And he also didn't address the point, at least not directly, in relation to the events, which I think I may have touched on earlier, in 2021 when Bearley Farm came up for sale. At that point, Matthew was asked, wanted to buy the farm. They would have had to borrow £7.5 million. That was more than double the amount of the partnership borrowing at that point. It would taken many years for that borrowing to be paid off, bearing in mind both brothers were in their 50s. That again casts doubt, well, it does more than cast doubt, it essentially establishes that any belief that Matthew's, that Daniel's involvement was going to be time limited cannot have been persisting at that point. And the irony is judge addressed that point indirectly, but not in the way that I invited him to, at paragraph 199 of his judgment, page 91 in the full bundle. So paragraph 199, he wonders about the difficulty in the proprietary estoppel analysis by contemplating what the effect would have been if they had acquired Bearley Farm for the partnership. And he says, however, such a significant expansion of the partnership's business 15 years or so after the assurance would raise questions as to whether Matthew could establish that he was still then relying upon it and doing so to his detriment. It would also cause the court to wonder whether applying the yardstick of unconscionability, which in my submission he doesn't apply in relation to earlier events, Daniel should be held to an assurance given in relation to the farm as it was in 2005-06 when the property partnership had been so significantly expanded through his joint effort.
You say the same applies to the dairy?
Absolutely, my lord. I mean, that is his case. His case is he relies upon it in 2013 by causing the partnership to embark upon this expansion plan and borrow so much money. But the judge just doesn't deal with it in his.
On this basis, I think there may be a slight shift in your case in the sense that you've been saying, well, it wasn't reasonable to continue to rely. Here, the judge isn't just talking about whether it's reasonable still to rely, but whether there is continuing reliance and continuing reliance to Matthew's detriment.
Yes, but I apologise if that comes across as a shift. It wasn't intended to be a shift.
Well, I'm not saying you shouldn't run both arguments, but the focus seemed to be before on the reasonableness of reliance.
Yes.
Here the judge is saying, well, there'd be questions about actual reliance and reliance to detriment.
It comes to both, my lord, and I apologise if I haven't been clear about that, because it's exactly the same question in 2013 when the decision is taken to expand, and the points that I made about the conversation about the three-way split of the inheritance, that itself goes to the question of whether Matthew can have been relying upon it at that point. But there's also this fact, which again Matthew accepted in his evidence, that he didn't raise any of this with Daniel. He never said anything to Daniel about any of this. In fact, his evidence was that he walked on eggshells effectively because he didn't want to put Daniel off. And that goes to questions about whether or not there was such an understanding in the first place. But it also goes to questions of whether or not there was a continuing understanding and whether it was reasonable, if there was any such understanding on Matthew's part, to continue to rely upon it. And it also goes to questions of conscionability as well, or unconscionability. And none of these are points which are addressed by the judge in his judgment, even though I expressly asked him to do so, and I made the point repeatedly in my closing submissions, which I don't think I need to take you to, but the transcript of which is in the bundle. So if he was right, if he was right to find that an equity of this nature could have been something which in principle would amount to an exception, he was wrong to find that the equity was made out on the basis of the evidence that was put to him. Yeah. He didn't pay due regard to what was actually said by Matthew in his evidence about what was said, and he didn't take into account the various points which he should have taken into account in determining whether or not the equity had been made out.
Yes.
Just trying to do a mental checklist to see what else
Well,
I can assist your lodgers
well-
within my final 10 minutes.
One question is, what would follow if you were right about that? So suppose we ultimately concluded, well, in principle, a proprietary estoppel type point could run, but the judge had not, in his judgment, adequately explained that it actually runs in this case. Now, what would we then do?
You should set aside his order, and then there are two choices, I think. The first would be to make an order for sale with permission for both parties to bid and remit the case to the High Court in Bristol for it to deal with questions relating to the mechanics of the sale and the necessary accounting process which would inevitably be included, which I would say in passing is a process in which the involvement, the evidence which Matthew has sought to put in for this hearing could be taken into account. The alternative would be a variety of that, which would be to set aside the order and to remit the case to the judge for him to decide what order to make in the light of your lordship's judgment.
And what would you contemplate there?
Well, I would be asking him again to make an order along those lines, but the order that he would make would be one which would be open to him to make on the availability of the evidence, which is.
Do you mean that he would be deciding afresh, given your criticisms of what he didn't deal with, whether the proprietary estoppel type argument was sustained?
No, I would not invite him to do that, because that's something which he hasn't done.
You're not asking for a retrial, are you?
I'm not asking for a retrial. No. I would be submitting that he should make an order which gives due effect to whatever your judgment is,
Yeah.
my lord. And obviously, it's a little bit difficult to predict what that would be, as you will appreciate. But essentially, it's either it's either this court which makes an order which sets the course, or it is the judge, but on the basis of what you say.
What's a bit tricky on this is you say, well, there are various things the judge hasn't taken into account or hasn't made findings on. That leaves open the possibility that if he did take those things into account and made findings on the points, he would end up at the same point. So why shouldn't that, on this thesis, be a possibility?
Well, that would. I'd submit that wouldn't be the appropriate course to adopt, because the trial has happened. The claimant has had the opportunity to put his case.
So you're not actually asking us to remit the case to the judge to make further findings.
No.
You say, well, Matthew's had his chance. If the judge inadequately reasoned his conclusion, that's that. It should just be set aside and a sale made.
Yes. Yes, I think on reflection, that is what I'm saying.
So there's nothing to go back to the judge on this basis.
Well, there's the process of dealing with the
mechanics, but that
mechanics.
doesn't need to be Judge
Yes.
Russen.
No, I think that's right, my lord. Yes.
Yeah. All right.
I was just going to very quickly comment on the points where it said that there are various other factors which supported his decision. First of all, I would submit those can only be subsidiary points. And secondly, to the extent that it's said that there was a failing on Daniel's part in not addressing those points, and I'm thinking particularly about the taxation point, but it also goes to the fact that the herd is owned by Cobden Farms Limited and so on. In my submission, those points, those criticisms are unfair because those are not reasons given by Matthew in his particular claim as reasons why the court should be making a size order or a corruptio stopelish type order. He pleads specific reasons at page 172 in the core bundle, and there's no mention of any of those particular things, and it's for that reason that there was no evidence, there's none on my side, put forward at trial on those particular points, and why even if there might have been matters which would have been relevant if they had been pleaded and evidenced, it wasn't. They're not matters which supported or were matters which should have been taken into account by the judge in arriving at his decision. And they're not matters which tip the balance in favour of a size order.
Just going back for a moment to the pleading, and you showed us that there was a specific reference to the dairy in 2013. But if one looks at paragraph 86 of the pleading, page 172, 86A, the pleadings of the 2005 conversation form the basis for everything that Matthew did in relation to the partnership after the conversation. Invested all his time and resources and so on and so forth. So there is a rather more general plea than simply linking it to the dairy.
I accept that there's a plea, well, it's obviously there, but I've pointed out already that the paragraph 30, which ties
Yes.
the decision, and that's the substantive decision. Of course, he carries on working for the partnership thereafter, as indeed does Daniel. But the course is set at that point because the money has been invested. They've taken on these enormous loans.
Yeah.
May I just turn my back?
Yes. Are you going to say anything about your ground 3?
I covered, I thought, a little bit in my my opening point about valuation.
You've said what you want to say about it.
I think I have, but may I just?
Yeah. You certainly made the point that it's accord with maximising financial value for the partners to simply to rely on valuation rather than exposure to the real market. You've made that point.
Yes, and I suppose the other point, which it is still part of my appeal, which is as a general point, is that relying upon a valuation when there's no difficulty in selling the farm on the open market, and there would be no difficulty. There's none suggested by the valuer. That valuations have an inherent, not a flaw, but the valuation is just an opinion about what a property might fetch. Sure. So there's an inherent uncertainty, and I referred to the observations of or the findings of Lady Justice Andrews in Bahia in relation to that.
Yes.
I don't think I need to say more on that. So if I may just turn my back. I'm just about coming on time.
Thank you very much. Yes, Mr. Jordan.
May I please, Your Lordship, there are 3 grounds of appeal and 2 respondents' notice grounds. I will address the grounds of appeal and the first of the respondents' notice grounds, and Ms. Fairley will address the court on the second of our respondents' notice grounds, including the application to admit the written statement of
Yes.
Matthew Cobden. My learned friend's supplemental skeleton, paragraph 55, he says that when making an order for the sale of assets and the winding up of a partnership, the court acts in exercising its inherent jurisdiction. We submit that's incorrect. It's a statutory discretion under Section 39 of the Partnership Act, which is in bundle A1 of the authorities, tab B1, on page 12. And as has been pointed out in at least 3 of the cases, when Section 39 says that on the dissolution of a partnership, every partner is entitled to have the property of the partnership applied in payment of the debts and liabilities, or to have the surplus assets of such payment applied in payment of what may be due to the partners respectively. That doesn't require a sale. There's no statutory direction for a sale. And the BA in Section 39 says that any partner may apply to the court to wind up the business and affairs of the firm. And that gives the court a discretion as to the appropriate order to be made for the winding up. So this is an appeal against the exercise of a statutory discretion and should be approached in accordance with the usual principles which apply to such an appeal, which can be sufficiently well known to the court for the right to.
But wasn't that submission rejected in Bahia?
No, no, my lord, that wasn't rejected in Bahia. What was said in Bahia is that when making an order under Section 39, the usual order which would produce justice is direct and open market sale. But the court has a discretion to depart from the usual course. I'll come on to address in what circumstances that would be appropriate. What was being said in Bahia is that in exercising the Section 39 discretion, the sale should be ordered because it will produce justice, unless there are reasons why it won't produce justice, in which case it shouldn't be ordered. So the court was giving guidance on the exercise of the discretion, but it wasn't saying there wasn't a discretion. My learned friend has spent some time making submissions on the judge's findings of fact, and again the principles which apply to an appeal against the judge's findings of fact are very well known, and indeed I think all 3 of your lordships have pronounced on them in different judgments. Having said that, I hope it would be acceptable for me to briefly remind the court of just 1 or 2 points in relation to that by reference to Lord Justice Leggatt's judgment in a case called JSC Bank against Mayersoff, which is in volume 2 of the authorities, tab E15. This was a case about Mr. Appellant, who had embezzled vast sums of money from the bank, and the issue in the case was whether a payment of £1.9 million made by him to his son had been made for the purpose of putting assets beyond the reach of the bank, and the trial judge held it had not, and the appeal was dismissed. So the case was one which turned on an evaluation of the facts to decide whether one of the purposes for which the payment had been made was to put the money beyond the reach of the bank. And if I can ask you to turn to page 407. Paragraph 40. Lord Justice Leggett said it's convenient to distinguish, although the difference
You
is
needn't
really
read this
one of
aloud. We
degrees.
can read it for ourselves, Mr. Jordan.
Thank you.
If you want us to read 41 as well.
Please. This is, of course, familiar material, and in this case, His Honour Judge Russen had a familiarity with the case which a Court of Appeal, however distinguished, can't match. He had dealt with a number of interim applications and pre-trial reviews. He had a substantial trial bundle, much larger than the material in the supplementary bundle. We have the trial bundle here in case we do need to refer to any of it. You can see it was very substantial. The material before this court is necessarily in a small fraction of the material which he had to consider. And of course, as said in other cases, it's not possible to recreate the atmosphere of the courtroom simply by looking at transcripts. We have some short extracts from witness statements and transcripts, but they only record the words used, and a large part of communication comes from tone of voice, facial expressions, body language, which transcripts can't capture. And that leads to the conclusion of paragraph 43, that for those reasons and others, it's firmly established that an appellate court should only state a finding of fact, including evaluation, if the conclusion is plainly wrong. At the end, he says, one that no reasonable judge would have reached. So that is the test here. Can this court be satisfied that it can conclude that Honour Judge Russen's conclusions on the facts were ones no reasonable judge in his position could have reached? There's one other point to make about the judgment. It was produced very quickly for the reasons explained by the judge in paragraph 412. He said that if you're making a size order based on valuations, it's important to deal with the matter quickly because values can change. The trial concluded on the 17th of May. There were written submissions on Bahia and Sidhu in June, and the draft judgment was circulated on the 20th of June, so the evidence was fresh in the judge's mind. And he made clear at paragraph 216 of the judgment that he couldn't summarise all of the evidence in his judgment, which he said was long enough already. There is an account of the facts in my learned friend's skeleton argument for this appeal. That account differs in a number of respects from the judgment, and we would ask the court to take the facts from the judgment and not from my learned friend's skeleton argument. Turning then to the first ground of appeal and what Bahia decided. If we could turn back to Bahia, which is in volume 1 of the authorities, tab E3, starting at page 100. Page 107, paragraphs 5 and 6.
Yeah, I think we've read these.
Yes, and so in paragraph 6, Lady Justice Andrews says there may be circumstances in which realisation is on the open market is not feasible or would produce an unjust outcome. So those are the two possibilities. And then page 116, paragraph 48.
Which says it again at 28.
Yes.
Page 111. There may be cases in which an open market sale would not be the best means of achieving full value or would be unfair.
Yes. So our submission is that this case doesn't decide, but only questions of how much money you can make must be taken into account. It recognises that there may be other factors. And page 111. Paragraph 39, she refers to Mullins and Lawson, and she recognises in the last sentence any such sale would also have an adverse impact on employees, creditors and insolvent persons. So it's not just the question of the impact on the partners themselves that needs to be taken into account.
Sorry, I've got lost. Where are you?
Page 114, paragraph 39, when she's summarising Mr. Justice Newberger's decision in Mullins and Lawton, in the last sentence there, just above letter H, any such sale would also have had an adverse impact on employees, creditors, and insolvent persons under the substantial number of insolvencies for which the partners were responsible. Recognising that an impact on third parties may need to be taken into account, not just the impact on the partners themselves. And in paragraph 44, on the next page, she says the types of case in which exceptional circumstances have been found to exist, or if it's been envisaged there might be justification from departing from the general practice. The first one is where one partner has a very small stake and selling the partnership business as a going concern would create disproportionate injury to the majority partners and or to third parties such as customers of the business. So again, there's recognition that an impact on third parties can be taken into account, which is relevant to the position of Jill Cobden. And the third category is where even if the terms were breached, the partnership agreement makes provision for a buyout on termination of the partnership, or it can properly be inferred that this is what the contracting parties intended. So there is an alternative to a contract, and something that can be discerned from the evidence is what the parties intended should happen. My learned friend has already accepted, I think, that these categories are not exclusive, and rightly accepted that. So we say it's not necessary for us to shoehorn this case, and it wasn't necessary for Judge Russen to shoehorn this case into one of those categories, but it plainly has similarities to that third category. Lady Justice Andrews endorsed what Justice Hoffman had said in Hammond and Brearley about making an order departing from the usual course only in an exceptional case, which he quotes from Hammond and Brearley at the bottom of page 111. We've quoted in our skeleton argument at paragraph 19 what is a discussion of what is meant by exceptional circumstances. My own friend has indicated he agrees with the proposition we've quoted there, so we haven't included the authority in the bundle.
This is Lord Bingham, is it?
Yes, Lord Bingham in Queen against Kelly.
Yeah.
And if we could just turn up skeleton argument at core bundle page 209, paragraph 19.
Yes.
Exceptional is an ordinary familiar English adjective, describes a circumstance which to form an exception out of the ordinary course, or unusual, special or uncommon, need not be unique or unprecedented or very rare, but can't be one regularly or routinely or normally encountered. So all that Bahir and Sidhu decided was that if there isn't anything which makes it unjust to order a sale on the open market, the court should order a sale on the open market. And in that particular case, the factors identified by Mr. Thompson as justifying a sale evaluation didn't justify the order, because he accepted himself that there was nothing unjust about a sale on the open market, and the factors he took into account were quite incapable of justifying the order that he made.
So how much of a weighting, if any, do you give to the default position?
The default position is exactly that. It is the right order to make. It will produce a just result unless there are other factors which mean that it won't produce a just result. And what those factors are can't be definitively defined, and shouldn't be definitively defined. And certainly the examples given in Bahir and Sidhu should not be treated as a comprehensive list. Judge Russen did have Bahir very firmly in mind. He received submissions on it. He dealt with it extensively in his judgment in numerous paragraphs, and in particular discussed it in detail in paragraphs 158 to 186. And he summarised the principles that he should apply in paragraph 191. It seemed to be suggested in the course of my learned friend's submissions that there was some misdirection in paragraph 191, but in my submission, if you read paragraph 191 as a whole, rather than picking out a sentence here and there is no misdirection. The judge directed himself correctly. Go to the core bundle, page 87. In paragraph Roman numeral 3, he said the default position is that the partnership assets will be sold, and a sire's order is exceptional, and then he explains why it's unusual. In Roman numeral 4, my learned friend said that the last sentence is incorrect. The test is whether, as an exception to the normal rule, the sire's order can be justified on the basis it would serve the interests of justice. And the facts of the particular case compare for here in situ at 45. He doesn't stop there and just leave it hanging as a sort of a matter of justice. He goes on to consider different types of case where the order will not produce justice.
But at the beginning of 5, he says one other type of case. So that's different, is it, from what's contemplated at the end of 4?
What one other type of case, other than the examples that were given in Bahia and Sidu at paragraph 44? Because in sub-Roman number 4, he says examples of some were given in Bahia and Sidu at 44.
Yes, I see.
Then he says one other type of case.
Okay.
And then he goes on to consider where proprietary estoppel principles apply.
Can I just ask you about one little bit of 1913? He says the default position is that the assets will be sold. Sire's orders is exceptional. He goes on to say it's unusual, not least because it will involve the successors to the business taking on the debts owed to creditors and indemnifying others, rather than all the debts being crystallised and all creditors being paid using liquidated assets. But section 39 says that a partner is entitled to have the property of the partnership applied in payment of the debts and liabilities of the firm. So that is a departure, isn't it, from what the section appears to require.
But the mechanics of a sale, certainly in the present case, were that the existing indebtedness was all released and then new debt was taken on by the purchasers. So the debts were satisfied out of the assets of the partnership.
That's, yes, I see. It's not what the judge is contemplating in 1913. He's talking about an indemnity from the continuing partner to the outgoing partner, which is not the same as paying a debt. I mean, you know perfectly well if a debt's paid, it's paid, but if you've got an indemnity from somebody, it may be worthless, depending on how they prosper.
Yeah. Well, I see that point, although it may depend on the mechanics of how the order is given effect to. In Sires and Sires itself, the way that the order was given effect to was by an assessment being made of the value of the music hall and the tavern as a going concern at the date of the notice of dissolution, and then on payment of 1/8 of that, no further accounts were to be taken. So that seemed to leave Daniel Sires still exposed to all the creditors of the business, if there were any.
Yeah.
Although with a right of indemnity against Morris Sires.
Well, that's not the case here, you're saying.
Not the case here, no. I think there was
Yes.
an indemnity. Sorry, no. My learned friend said that there's no case like this one in which a sire's order would be made no authority for what the judge did. Nor is there any case in which a similar situation has arisen and the court has said the considerations that the judge took into account shouldn't have been taken into account. Most disputes settle, so you'd expect in a situation where there are exceptional circumstances of the kind here, that the parties would recognise that and agree between themselves that there should be a buyout rather than having to go to court at all. There is the case of Ansell and Ansell that my learned friend showed the court. I'd just like to go back to that, if I may, to explain what I suggest Justice Hart meant by equities in that case.
It's not easy to get very much out of a single phrase in an extemporary judgment or an interim application.
Well, perhaps I'll just make my submission then on what I suggest he meant. What he meant is, if you read his judgment, is that the claim by Roddy that there was a binding agreement that he should acquire the partnership assets looked pretty shaky. But the parties had clearly been negotiating on the basis that he would take over the partnership properties and in return would give up his interest in the company.
Yeah.
And in those circumstances, it might well be that even if there wasn't an agreement, it was sufficient to make it unjust for the other partner to refuse to allow the partnership properties to be transferred to him based on a valuation.
Yeah.
So it was a case where, not where it was decided that a similar situation to this would lead to a sire's order, but at least a case where another judge recognised that it was a serious possibility and made an interim order having regard to that. I can't take it further than that.
All right, well, will that be a convenient moment to break, Mr.
Yes,
Jordan?
Lord.
2 o'clock.
Scott Rice.